Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today, we're going to talk about human rights, the Human Rights Tribunal, and much more. So today, I'm joined by Leon and Sophia. So first of all, thanks for both of you for joining. And let's maybe start with Leon. Maybe you could do a quick bio there. I'll tell us a little bit more about yourself, and then we'll go over to Sophia after.
Okay, thank you very much, Jean-Paul. My name is Levy-Presner, and I am a paralegal in Pickering, Ontario. Business that I run is called Defendant Legal Services Professional Corporation, and it's a multidisciplinary firm that deals with legal issues. I'm also a private investigation agency, and I am a RCMP background screening officer.
And Sophia?
Sophia Levy-Presner. So I work with Defendant Legal Services as well, but I also own Building Blocks HR. I build HR departments from the ground up. So within Defendant, I handle all the human rights and employment, any WSIB benefits that come through the door. My designation allows me to actually participate in tribunals and everything like that when it comes to human rights and employment and WSIB.
All right, so I wanted to, I guess, maybe start with kind of walking through a human rights type of issue that, let's say, comes up in an employment context. So let's say someone comes and certainly you can kind of fill in the example here, but let's say an employee says, this has been going on and being discriminated at my place of employment. Pick kind of what the consequence is. So maybe Sophia, you can kind of walk us through the different steps in the process there, and then I guess maybe I can go to Leon then from the response there on the employer side, so we can kind of go through step by step, from beginning to end, how it works with a human rights complaint.
So when we receive a human rights complaint, and if it's an employment, it could be race, it could be disability, it could be age. We've had all of them. So the client will come to us and they'll provide all their documentation, evidence that shows that they've been discriminated. And what I do is I make sure and ask tough questions to make sure that there actually is a discrimination case, because you don't want to do all the work and then it get thrown out at the board. So once you decide that yes, it is actually a discrimination case, so we put together a Schedule A, and it basically goes through what the cause of action was, what was the main date that the discrimination occurred, and then everything else before or after it. And then there's, so we put together the points on everything to do with that discrimination, the background, what has happened, any evidence, any witnesses that might be there, and we put the story together. And then we'll complete the application form that goes with the Schedule A. And then once that is completed, and you only have a year to file any discrimination cases. So you always have to make sure that you're within that timeline, because it's very difficult to file it after the year is the year from the cause of action date. So once we file it, we usually get a number pretty quickly from HRTO, and then we wait because then the other side has to get the documents, which could take anywhere between 3 to 6 months. And once they receive their information, they'll respond to us and provide a reply. And then we can also reply back to it if there's any additional information that we have to add. And then we wait for a mediation date. And a mediation date or mediation is when the two sides can come together to see if they can settle before it actually goes to a full trial.
All right, so maybe it's a good chance there to turn over to Leon about, let's say someone now has come to you and they say, well, one of my employees or whatever the situation might be, and I've received this application. What are the steps then on their end before we get to, as Sophia pointed out, a mediation date potentially?
Okay, especially with employers, they have lots of regulatory items that they must have. Do you have a discrimination policy? Do you have a workplace harassment policy? Do you have AOTA? All of these types of different types of legislative things, we're going to make sure that those boxes are checked, because that may be the issue in itself, that the business or the company doesn't have a policy. And when you don't have a policy, you're not following the rules, or you may not even know the rules. And some of these companies get into trouble. What often can be also done is an investigation where we interview, obviously, and we get all the facts of what happened here and why this happened, so that we can provide a good defense to the if we get a human rights complaint from that side, how we can respond to it. And where we see the worst part of businesses is that they don't do proper investigations. They don't investigate all the parties involved and how all this contributed to the complaint, because that's really important. And we have seen, when we represent people on the other side, the lack of these types of things. And that's to our advantage, because we can poke holes into their allegations.
And Sophia, you brought up about it being a 12-month, you got to get it in within a year. But, usually in some, I'm not going to say usually, but oftentimes you have situations at, employers where it's not like one isolated incident, right? I mean, it could be when they came in for the interview, there was some kind of discrimination. And then in the position, it's getting ongoing. Is it 12 months when it first started, or when does that calculation kick in?
Well, it's the last date. So the last date of the discrimination. So it could have started at hire, and then it continued during the employment. So even if the person was hired, January 1, and then the discrimination continued to occur throughout the whole year, it's the last date that the last incident of the discrimination occurred. So if September, there was another incident that occurred, you can use the September date, and you have a year from that to file.
And I guess then let's maybe look at mediation. You brought up mediation. So there's a response, right? And you're waiting for mediation. So how, in terms of the applicant, they're getting ready for potential mediation, what are some of the things that they're looking at, and what are some possibilities in terms of how mediation plays out?
So what happens in mediation is, and now it's all on Zoom. So the mediator will talk to both sides first, go through the rules, the confidentiality, and then split them up into groups. So the respondents will go to one side, and then the applicant goes to another side, so breakout room. The mediator would come to the applicant first, and then goes through all the details that was provided in the application in the Schedule A. So what we do to prep is we get the information from the other side, their reply, so that we know exactly what their position is. And we just formulate our answers around that, and to tell our story of, what's happened, the pain and suffering that has that the applicant has suffered. And this is why we're, looking for certain monetary or non-monetary items. And it just goes back and forth. So the mediator would come to the applicant first. It could take, the first 45 minutes. And then the mediator would go over to the respondent. And we would just go back and forth until we can come up with a settlement. And if we don't settle, then it goes to trial. But at that time that it will go to trial, it then becomes public, and it will eventually end up in Canley for a case law.
Yeah, Leon. So with that in mind, now from the employer perspective, right? I mean, when it's first at mediation, is that a concern that is brought up there? I mean, from you to potential clients, right? Is that, well, if we don't resolve this, it may not necessarily be what happens in this particular incident, but the perception in the media, or the perception in the legal community, or just the community at large, that there's a finding in Can Lee about your company, and that is going to have more impact. I mean, are those some of those things that are taking in place? And maybe you can look at mediation now from the respondent side.
Yes, it's always great jeopardy for the employer or a company when you're approaching and you're within this process. Sometimes there's even preliminary issues where even before mediation, there could be some issues, and some of those things, if an adjudicator or a decision maker makes a decision, that could actually get out there and broadcast on Can Lee. That, say for instance, the other side didn't file on time, and there's this discourse of back and forth of getting information. The other side may be ordered to disclose the information, and that order could end up out there on Can Lee. So there's a lot of jeopardy when it comes to human rights tribunal matters, especially involving a business. It's your reputation, there's liability, there's all these types of things. So if things can be resolved, I always encourage that these things are resolved and keep it within the mediation realm. Sometimes you can't come to a conclusion. Sometimes your client is either they don't want to settle, or they're entrenched, or they just don't feel that they're wronged and they are correct, and they will take that risk in going to a trial situation. But my notion is always to try to resolve things and to keep it out of a trial situation. But it's ultimately the employer's or the company's decision, and we're going to follow that decision. I may, as I said, I may advise them that may not be the most prudent, but at times, we have to go with what the client wants and what the client ultimately wants, and they have to. My job is to inform them of the inherent risks and jeopardies in going forward.
Now, Sophia, from the applicant side, I mean, do you see that, well, hey, no, they're not, I'm not getting, if it's compensation, or if there's some other a remedy that they're looking for? I mean, how is that from an applicant perspective there to what Leon brought up? Or are they saying, in terms of the principle, I'd want to go to a hearing, I want this to be decided, and I don't feel that they're kind of meeting me part way in terms of addressing the things in the application?
So in some cases with the applicant, the applicant just wants this to go away. It's been a long time, they've suffered enough and they want to settle, but they want it to be a fair process. So, for example, if, the monetary amount was, we asked for $15,000 for pain and suffering and other things, and the company or the employer comes back with $1,000. We know that they're really not there to negotiate fairly, and they really didn't come to make any effort to try to settle. So then that's when the applicant has to decide that they want to take it to trial. And some want to take it to trial just the mere fact that if you settle in a mediation, it does not go public. But some applicants want it to go public, because sometimes when it doesn't go public, nobody ever knows that these types of discrimination is actually occurring. So some of them don't want to settle because they want it to be public, so everybody knows what's going on.
Now, Leon, we were just talking there about numbers and being a licensed paralegal. A lot of paralegals know the number, $35,000 for a small claims court as being the monetary jurisdiction. Is there a similar kind of number in human rights hearings, or at a point that it gets out of the scope of a paralegal to do?
This is the interesting thing. There is no monetary jurisdiction at the Human Rights Tribunal. So theoretically, sure, you could sue somebody for $250,000 as a paralegal. But the tribunal has limits of awards that they've given to certain types of situations. For example, we were involved in a particular situation with a certain entity, and we were the second highest of the award that ever was issued in Ontario for our case. So the numbers have to be realistic. We tell our clients very, very succinctly, very, very directly that this is not a money-making operation. This is something to redress discrimination in a fair and judicial manner. And if you want to come to the tribunal and ask for $1 million, you will not get it. Right? It's something that that is reasonable to address the issues. And it's not like US courts or these types of things. It's, I guess with our experience, a lot of awards are, 10,000, 20,000 around there, but we've had much more significant ones. But it all depends on what has been in the past, and especially mediation. The mediator will often comment if your monetary amounts are too high. They'll make a note of that, of what they have seen. So we also try to school our clients. Let's be realistic about what you're asking for.
Now, Sophia, so if it doesn't resolve, right? So you mentioned it goes to the hearing. So what's in terms of preparing for the fact that it's going to go to a hearing? And is that, I mean, if mediation doesn't work at that first stage, is that the end of trying to get a resolution, or are we kind of full speed ahead now with a hearing having to take place in, a few months down the road?
Now, there are times that there could be a second mediation because they really want to settle this. It just depends on if there's anything in between the first mediation and the possibility of a trial. So there could be a second mediation. But with the trial, we're actually preparing for a trial right now, which is going to take place next week. And we've been basically gathering information since March and there's a lot of information that you have to put together. So you get a direction from HRTO, what they want to see at certain periods of time before the trial occurs. And you have to get all those information together. So your book of documents, your book of authorities, the documents that you're going to rely on, witnesses, anything like that. It takes a lot of time and a lot of work, but a trial often, so, if the mediation happens today, for example, a trial could be 2-3 years down the road. So it doesn't happen quickly. The only time I've seen a trial happen fairly quickly is within the Canadian human rights. So it's very different from the Ontario human rights.
And so let's fast forward, a week from now, right? That whatever the hearing date is, what, Leon, maybe in terms of, the delivery there, what's it like in terms of the hearing itself? From, I mean, you could take either perspective, but in terms of witnesses and procedure.
The procedure is court-like, if I could say. It's not. It's very structured, and it's court. It's in the same format as your examination in chief, your opening statements, your presenting of evidence. It's court. Although it's at the tribunal level, it's treated as court, and many rules, and you have to follow all the rules, or you can have an objection from the other side. So you have to be skilled in court procedure and examinations in chief and cross-examining your respective witnesses and persons that are affected by the application.
Sophia, in terms of certainly the hearings, are they back in person? Are they still being done on Zoom? What's the plan for next week there?
It's Zoom, and it's going to be, it'll start at 9:30 and go to 5. So it's an all-day thing on Zoom, hopefully with a bit of breaks.
And what are your thoughts of things being on Zoom? Because every time I talk to people that have been doing things online, I mean, I get all sorts of different responses. Some people are, concerned about, someone reading off off camera, their notes. Some people think, well, it's great because you can see them right in the center of your screen when you're asking questions. And to assess, things like credibility. Others think, well, it's way different than if you were in, a room and everyone was all in that room. So what are your thoughts? What are you thinking? What are your concerns maybe next week going into this hearing if it does go forward?
Well, the information that we had to provide is so specific. So we can only rely on the information that we've provided. So if there's something totally different that is being communicated to us and we're looking for it, we know that it hasn't been provided and they're reading it off of something else. So that's where, the judge will step in and say, okay, I don't have that information. Where are you reading this from? So it's hard to actually, filter in any other type of information into this type of hearing, because we had to submit all the documentation prior to the actual trial date. So, but I personally, Zoom or in person, I'm okay with either or.
And Leon, do you have any tips, tricks for students or newly licensed paralegals that would be going and doing a hearing and maybe their first hearing? I mean, on Zoom or in person, whatever, in terms of presenting evidence or asking questions of witnesses. So maybe you could take sort of the direct examination and going through some of the evidence and testimony in that regard.
Yeah, the best thing is, the best learning is to observe and to watch maybe different trials, full trials on how they play out in different forums, such as POA court would be a great start. Just even, and those are minor, traffic ticket type of things, but the structure is always the same. And criminal court, which probably be more interesting to watch some of those cases and how they play out and how court testimony is played out, and then the cross-examination of the questioning. The landlord-tenant board is sort of a looser version of formal court, but it's also a very, very good place to get your feet wet, especially, and being comfortable in a court setting, because all eyes are on you and what you're saying and how you're asking questions and how you're presenting yourself is really important.
Sophia, anything to add in terms from your perspective of any tips, tricks, or techniques there that before the tribunal that would be helpful for students and newly licensed paralegals or anyone else listening to do a better performance at the tribunal?
It's important to be prepared for what, whether it's mediation or the trial. Of course, trial, there's a lot more information that you have to gather to be prepared. But even in the mediation, you have to make sure that when you're speaking to the mediator, you have to get all your points across on, why this discrimination case application was put forward, and what you truly want to get out of this. So it's important to get connected with that mediator so that the mediator will go back and communicate exactly what you want the company to hear or the employer to hear, all of your pain and suffering. So that's a key when it comes to mediation, because with some mediations, you only either have 3 hours. The school board ones, they always do a full day because they want to settle it. They do not want it to go to trial. So you have a little bit more time to really go back and forth to get that information to the other side so that, this can, so that it can settle. But with the trial, you have to make sure you're prepared with your questions. With the trial going on next week for the human rights, we've started preparing, within the last 2 weeks, we've got our questions. We've talked to the respondent, how we're going to go through everything, what we think the side is going to bring forward. So we've just kind of had to go through the pros and cons on where we think this is going, and poking holes in all the information. So we have everything written down and ready to go. So it's the key is to really be prepared and organized.
And then, Leon, what happens after? So everyone finishes, they've made any final submissions. Do you typically get a decision that day? Like, are you going to get it right away, or is it going to be reserved? And kind of how long are you waiting for?
That's highly variable. Sometimes there could be a decision. More often it's reserved, and because usually the orders are quite detailed with a lot of information. They're not just one-page orders. They're usually multi-page orders, and lots of legal issues that are articulated on those orders. So generally, what I have seen is that they reserve judgment and they come back, and it could be anywhere from a couple of weeks to months. I've had to wait 2 months for an order.
And Sophia, in terms of orders, like, we were talking about compensation, and it's not, these $1 million awards and typically large amounts, like we were mentioning, 15, 20,000, like that. What are some of the other things that the Human Rights Tribunal can award as a remedy in that order?
So the non-monetary, so policy changes, can be key. Certain type of training. So, there's the anti-Black racism training and things like that a lot of applicants will put in that may be missing in their organization. So I've found that there's a lot of that applicants will ask for, as well as, it could be therapy. So there's therapy that could be asked for. So, it just depends on what the situation is, what the discrimination is, what was lacking in the company. And those are the things that we're presenting that hopefully that the company will want to change or revise to make it a better employment for others. Because that's also the key too, is to make it better for others, not just the individual that's present.
And Leon, does the tribunal typically award any costs or anything like that, or is it just you're looking at either the monetary or non-monetary compensation there, and that's pretty much what you're getting?
Yes, I tend to ask for general damages, so one big lump for general damages, and usually, and what Sophia had stated, some maybe some remedial things that we would ask, training, those types of things.
And Sophia, if there isn't, let's say the result that the applicant is looking for, even the respondent, I suppose, is that kind of the last resort there with the tribunal? Do you see, are there opportunities for like reconsideration or appeal routes, or are those not very common at all?
Not common. Like I said, there could be a reconsideration if there's additional information that could be provided, so that you have a second mediation, that you can settle it. But if you don't settle it, again, it goes to trial, and then you have more opportunities to bring forth more information. So once the mediation occurs, that information is not filtered to the trial. So basically, the trial it's a judge. It's new information, or not new information, but information that wasn't stated possibly at the mediation. So none of the mediation information can be brought forward. That's strictly confidential.
And Leon, we were talking a bit about the Canadian Human Rights Tribunal before. I mean, besides the federal versus provincial regulated workplaces, I mean, any difference in structure there versus at the HRTO in terms of, I know I mentioned, I think Sophia had mentioned it's a lot faster turnaround, but no, any substantial differences in getting from point A to point B from beginning to end.
So I might have to answer that question for Leo.
Okay, yeah, Sophia, take it away.
So with their structure, they automatically offer two mediations. So one's a mediation and one's a conciliation, because they really want you to settle outside of a trial. And so far we have settled, whether if it's not the first mediation, it's been in the conciliation that we've settled with the cases that we've had. And they go through different steps where they're constantly asking you to reply to information, even though you might have replied to it before. They're asking you to keep replying so that you can get to a settlement instead of going to trial. So it's a really different process and it's a quicker process.
Perfect. Thanks for that. And Leon, I guess you're not safe for the next question here, I guess, but for paralegals, young paralegals, newly licensed paralegals, or even students right now who are thinking about wanting to do human rights, and there's certainly a push, even from the Law Society of, let's get outside of the big three, right? Landlord, tenant, provincial offenses, small claims. Now, and you've already mentioned one of the big things there which is going and observing proceedings and getting that experience. What else can they do in terms of better getting acquainted with kind of the process and feeling more comfortable, right? I mean, I think a lot of paralegals, once they get licensed, they're like, well, what's next? And then they don't know what to do, right? In terms of they're not ready maybe to start their own practice, or they're not sure they've command enough of the subject matter expertise, perhaps, to do things on their own. What can you share kind of from making your jump there from being a student there, getting licensed, and then going into defendant?
Well, it's like anything, right? We tend to gravitate to things that we know and things that we're comfortable with and things maybe we've had previous education in. So Sophia and myself are both university graduates in sociology. So we have already been exposed to much, the study of society, right? So we have a good understanding of what is going on out there. Sophia's, for instance, has many years. Don't quote me, Sophia, 30 plus years of of HR experience. So she's always dealing with people and the interaction and the interplay with people and business and all that type of stuff. Myself, I was a police officer for 27 and a half years. So in a less formal sense, but more hands-on, another social type of thing. So we tend to gravitate to things that we're comfortable. What I could say for new students, if you have a passion, you follow it and you grab it and you follow it. So if say for instance, if you're interested in social justice and social issues and stuff, then yeah, HRTO is something that you should learn about and learn how you can learn how to do it. We've had some students that have come to our firm who their eyes are open wide because we're one of the few paralegal firms that extensively do human rights tribunal applications, and they're like, I never even knew that you could do this. Oh, this is really interesting. And we've really sparked a lot of interest through many of our students that have come through with our applications and trial situations or mediations that they're able to observe. Our last two students were absolutely fascinated. They just loved it, and their timing was good because we at that time we had those types of hearings that were coming up during their tenure at our firm. So again, people should follow their passion, and if even if you don't know if it's your passion, maybe go to a firm that specializes in those types of things and see if you like it, see if it interests you, see if you have the aptitude and the passion to be able to represent people or businesses either being accused or the reverse.
Now, Sophia, from the HR perspective, right? I mean, I think no, Leon may have mentioned it about policies and things like that. So when you're looking at, I mean, I would imagine the best advice is to avoid anything going to the HRTO to begin with. So maybe you could share some kind of advice for employers, typically, the smaller employers that may overlook things like creating these policies or going through investigations. Now, what are some of the biggest mistakes you've seen, in terms of employers managing kind of situations or failing to manage those kinds of situations before they spiral out and eventually lead to either a litigation at maybe small claims court or even matters before the HRTO?
Yeah, and it's a lot of the smaller companies, smaller to medium size, that may not have human resources that get themselves into trouble. So they always think that they can do whatever they want, but there's legislative policies that you must have in your organization, whether you're a small company or not. But some of the small companies believe that they don't need to have these policies, and then that's where the breach happens. And even in one of the human rights case, you're supposed to provide the policies up front when you come into the company. And they didn't provide it to the person, but they quickly did policies after it was breached, and they got a human rights complaint. So you could prove that, well, no, there wasn't any policies. They'd never seen these policies before, and they didn't exist. But that's what companies will try to do after the fact, is quickly try to get these policies in place, thinking that it's going to help their case, but it wasn't there in the first place. But the key for small and medium-sized companies is, it doesn't cost a lot to do the policies. If that's all that, you want out of human resources, the policies are key, because that's where all the breaches happen.
And Leon, I guess maybe from the other side, I mean, what happens when people are facing discrimination? Unfortunately, almost regular sometimes we're seeing in some companies, some places, and there's that sort of fear that if I go forward, something's going to happen. There's going to be a reprisal, and I'm just going to deal with it and just not say anything, right? I mean, what can we do? I mean, to better insulate those kinds of situations and provide more support for for example, the Law Society has the Discrimination and Harassment Council, and other organizations may have confidential places to go in and discuss. But what more can be done to, one, again, better address these situations, prevent them from even happening in the first place, but if they do happen, that people have those supports? And I guess, Sophia, you can take this as well after.
Mm-hmm.
That's a really good question. We were discussing, talking about this today, that often victims of these types of discriminatory acts, people talk about it, but they don't take action. So, sometimes you will see, and even with something as common right now as we're seeing, like landlord-tenant issues, right? People will go online and they'll talk about it, but they really don't know how to address it. These discriminatory things are very serious, and they can have very, very long lasting effects on your who you are, your self-esteem. You can even end up as PTSD, where if you're continually attacked and then you have a reaction to that. These are some really very serious things that can happen as a result of discrimination. And often, and that's why when Sophia had stated that the limitation dates are so important. Often we get people who come to us at the very, very last minute, where we literally have weeks, if that, to file an application, because they've sat there and chewed on it and thought about it for months and months and months. And then finally they get the revelation that maybe I should go talk to somebody. Talk to somebody who legally understands what's going on, to give you the proper direction. I don't understand sometimes with some people the rationale. Sometimes you have to spend a little bit of money to get the right answer. When you ask 30 people what they think, you're going to get 30 different versions of not the right answer. So sometimes you pick somebody who you think is competent and who you trust, and you have that candid conversation of, this is what's going on with me. What are my options? At least if you know what your options are, then you can take action if you want to take action. So now let's talk about taking action. When you take action, one thing that the board protects the person who is making the application, you're protected by the code, that if you make an application and your employer or the person, the other side, knows about it, if that person takes further action against you, that is a clear reprisal. And that is another sanction within the HRTO, very specifically. So people often fear that if I say something, I'm going to get harassed and I'm going to lose my job, and it's against the law. Does it happen? It can. But you, as the complainant, have to get to the point that if you're going to step up, then step up.
Sophia, yeah.
Yeah, so, and smaller companies will, it's very subtle threats that they'll tell an employee that, if you do this, this is what's going to happen to your job. So that's part of the reason why some employees will not come forward with any type of discrimination, because they're afraid they're going to lose their jobs. And there's been several clients that have come to us, and that was their biggest fear in not coming. But some of the discrimination was so bad that they had to do something. But there's many out there that the discrimination's happening, but they will never do anything. And sometimes it even involves your own kids, that they're not fighting enough for the kids. One, they're afraid, and two, sometimes they just don't know where to go. And there has to be something out there to make sure that people know that there are people that are willing to help with the discrimination.
Now, maybe Leon, and then we could go back to Sophia again. So something came up actually today in class. They were saying, well, what if the intention, is not, that people could understand, discrimination when it's overt, it's blatant, you can't kind of avoid it. But sometimes, I mean, or even like, in Canada, sometimes, we're not like the US, this stuff doesn't happen here. But it's more indirect, but it's still discriminatory, right? So what would you say, is the employer kind of get a pass if their intentions weren't exactly overt, or how does that get dealt with, either at the tribunal or just, in the process?
So this is where kind of knowing a little bit about discrimination and having some background in discrimination really helps. There's a sociological term called microaggressions. And if you went out and you went on the street and you asked, hey, do you know what a microaggression is? I'm going to say 95% of the 100 will not know. And microaggressions, maybe in a very colloquial kind of way of saying, it's death by 1,000 cuts, right? It's all the little things that a person or a company or an employer or a manager or a supervisor would do they're not calling you a name directly, but they're doing little tiny slights. And sometimes it's conscious and sometimes it's unconscious. And it just builds up, and it could be years of these types of things. It's like saying, oh, well, you kind of people, you guys do those types of things. Or, I only have black, you're the only black friend I have, right? Just, these are the little slights that people would say, and it's cumulative, and it affects people. And that is discrimination. Can you prove it? It's hard, because it's many, 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 many instances of lots of things that add up to maybe an event. That's one example. Sophia, do you have any other examples?
Well, I mean, there was one human rights case that we had, and, there was several people always making small comments to this individual. They were very subtle. Oh, you people, oh, it's great that you can do your hair in so many different styles, right? Or, oh, how do you get your hair looking like that? Little small things, or just, not including the person into the conversation with other people. So those are microaggressions and subtle discrimination as well. And this one individual and an employer, there was so many of them that it caused her to have PTSD, actually, for certain things that was always happening. So she would just freak out sometimes when things were happening and nobody knew why, but it was the constant microaggressions that she had experienced over the years, right, until she finally came to us. But it was all accumulative, right? There was one final incident, but we brought in all the background information of what has happened to her, and then the one incident that brought her to us.
And Sophia, I mean, with sort of all these microaggressions and things that are bubbling, is there, like, I mean, I guess everyone will have that breaking point that's different, but I mean, what can be done to sort of address that at sort of the earlier infancy stages, rather than it continuously spiraling? And the other thing is, I mean, especially over the last few years with COVID, that you're seeing workplaces, there's a lot of hybrid remote situations, and sometimes a lot of this is happening, online. Your traditional, let's say, lunchroom, right, where things would have been happening, or the water cooler is now on, I don't know, Facebook or somewhere where there's like a online presence, Twitter, right? That do keyboard warriors at work, is that treated any differently, or what kinds of concerns do you find now with a lot of these hybrid online situations that are different than when we were all at the office?
Well, I still think it happens, even though there's remote and not, the hybrid, some people are in the office. But I just think it's so important in a company to have those policies and to educate everyone. In your policy, on harassment or discrimination, there should be a section on microaggressions and subtle discrimination. Because yes, some people are genuinely unaware that they're doing that, but there are some people that it's intentional and it's just small jabs to really get under their skin. But for the ones that are unaware, I think it's important to have that education within the company so people understand how others may feel. And it's not just for race, it's for the gender, it's for the, I always say it wrong, the LGBTQ individuals. So it's for everyone, because they also experience all these microaggressions as well too.
And Leon, so we were talking about policies, but I mean, another issue is, all these companies, or maybe the medium to large size companies, they have, whether it's counsel or an HR department, and they draft, 50 of these policies, and then something happens and nobody goes to the policy, no one does the investigation. So, I mean, does having a policy matter if it's not being followed? I mean, what are some of the issues surrounding that?
Very good question. We deal with, we have some companies and some respondents where, you know, they're large that we deal with, and they have a plethora of policies. And again, are they following them? Are they, you know, it almost seems like now we're beyond the point of, so as Sophia stated, we have small to medium businesses that don't have policies. And then we have the other side, we have the big companies and the big entities that have ridiculous amount of policy, and people are not following them. So, you know, we actually had a recent mediation, and one of our, on our wish list to this company, we were asking to add some stuff to policy and stuff, and they just basically told us, look, we have that policy, we already have that policy, we've already done that. So how do you deal with that? You know, how do you deal with that when or I'll give you an example. We have a client where we represent, and we're representing against a very large entity, and part of their defense is this ridiculous amount of policy that they claim that their employees are following, and sent us plethora of policy. Clearly, you know, we are saying they didn't. They are saying we have lots and we did. So again, it's a balance of probabilities. Who's telling the truth here? You can have all this policy, but if nobody's following it, it's useless.
And sometimes some of the issues in a larger organization or even a smaller one, human resources may be very junior. So sometimes they're not completely understanding what needs to be done when it comes to policies, or understanding the whole employment law aspect of what's happening. So, and there's one incident where the individual, although they're called managers now or directors, and they're just coming out of school sometimes, they still haven't been in HR enough sometimes to understand their actions, but they think that they're doing well, but they're actually breaching their own policies and causing the discrimination to occur.
Now, Sophia, as well, I mean, you're seeing in recent times, you know, a lot of these initiatives, though EDI has become, you know, even in the legal field, and sometimes the EDI is, okay, well, we're going to do, you know, next month, we're going to have an event for Pride, and we're going to put, you know, rainbow signatures, and we're going to have, you know, some stuff on our website. And you know, that doesn't address, you know, the underlying issues, right? So what are you seeing, I guess, you know, if you could kind of speak broadly to, you know, what, regardless of the size of employers, but some of these things that they're not quite getting, you know, the issues, you know, surrounding the human rights, and they're doing kind of window dressing, right? I mean, I'm sure we could probably have a whole talk on just this itself, but I mean, what can be done better in addressing some of these situations? So again, to avoid things getting worse and ending up, you know, in the HRTO.
Well, and you use the right words, window dressing. So you have all these equity and diversity policies out there, but honestly, some of these policies are just for show, because they're really not putting any proper programs in place to actually execute this policy. And so the same issues continue to occur in an organization, right? So if you're actually going to put out a policy, have a plan, a program, and really execute it. And that's what I'm seeing is not occurring in a lot of companies. There's a lot of talk, even in some of the school boards. You know, they've added the human rights actually department now in a lot of the school boards, but yet there's all this discrimination still occurring. So again, I believe it's a bit of window dressing. So they're just putting out the policy to appease people. Oh yeah, we have a policy, but really there's no programs or anything attached to it. And I think that's where companies have to do a better job. If you're really going to put out that policy, actually put the program to it. So there's the inclusivity that goes with diversity. So sometimes you're missing that. You're just having a diversity and equity policy, but you have to have the inclusion as well.
Leon, anything to add to that in terms of what you're seeing in terms of, again, the phrase I use there, the window dressing, where it's like, there'll be like a land acknowledgement and then they don't do anything to address Indigenous issues in their organization other than read off, the sheet of paper at the start of the meeting or the event. Or I mean that could be for any other group, but just the first one that popped into my head. What more needs to be done, or what you're seeing there in terms of some of the clients and some of the respondents that you're dealing with?
Well, it's like anything, right? Mean as you say and follow through. I agree with you that reading off a piece of paper that you acknowledge the Indigenous people in this land right here. Okay, that's great. It's a start, but what more are we doing here? How are we addressing those issues? It's like anything, action and actually doing something. So say, for instance, you say, oh, well, I'm a diverse employer. Okay. So are you hiring diverse people? There's a good question, right? Are you reflecting the community that you're serving, right? Are you contributing to equity and treating people fairly? In our firm, we have so many different types of people, and I love it. And it's funny because the Law Society says, you have to have all this diversity. That's not we. If any firm that demonstrates diversity, we demonstrate diversity. We just our client base, who works here, everything. And our my motto is I just want good and smart people working here. I don't care what they look like, who they are, male or female, doesn't matter. I don't care. All I want is good people and smart people. And if more people behave like that, I think the world would be a better place and we would have less discriminatory allegations and issues out there in the world. When you start denying that these things are happening, or you say, well, why can't we all just be equal? It's not equal. So let's get away from that first. It's not equal. You may think it's equal because you're looking at it through your lens, but when you look at it through the lens of others, it's not so equal. So let's get over that part first and demonstrate that you are truly understanding and understanding the experiences of others. And then once you understand that, then it's easy. You don't have to have these policies because you're just doing it because it's the right thing to do. And again, that's how our firm works. And I think it's reflective out there of who comes to our firm.
All right. So last question here for both of you. Sophia, for any students who are interested in going in a path of HR or into the Human Rights Tribunal or in that direction, from your 30 plus years of experience there, any words of wisdom for them as they look to make those leaps into their career, and any final words, even on the topic here of human rights, for better dealing with this in our society?
Well, and Leon had said it earlier, it's about passion. Human resources, when I got involved in it, I wanted to make changes in companies to make it a better place to work. And that's exactly what I did. So that's why, my company, I build HR departments from the ground up so that I can do that in other companies to make it the best environment to work in. When it comes to human rights, I just have a passion. I have a passion to want to help people. I always have. I volunteer out in the community. But for me, when there's unfairness, I want to make it better. I want to make changes so that the world becomes a better place for the affected people. Whether, like I said, whether it's race, age, disability, or whatever the case may be. I want to fight for those individuals to make it a better place for them and others that follow.
And Leon, I guess then from the paralegal students obviously becoming licensed and practicing in this field or any other field, I mean, any final words? I know we've talked about all sorts of different issues over the years, but any final words for them as they look to get licensed and start practicing?
Yes, absolutely. Best thing is, and I've said it when I've come to see you, make sure you show up in class, pay attention, and have a plan. Have a plan and know what your interests are and be open to other interests. As paralegals in Ontario, I believe, has the most adjudicative tribunals in the world. So it doesn't just have to be landlord and tenant, because that's all you hear. There are so many other ones that I have. And if you understand the structure of administrative tribunals, certain ones are the same of how they do their adjudication, such as, say, LAT tribunal, a licensing application tribunal, and HRTO, and grievance settlement board, and there's so many. If you're good at numbers, do MPAC, right? Or if you come from the health field, maybe WSIB could be your passion, right? So there's I come from a policing background, so another passion, and Sophia, because of her HR, and myself with policing, we also do disciplinary hearings. So of the different colleges that are in Ontario, when people get into trouble for disciplinary things, we also represent those people. So the thing is to sit back and to get immersed, to take your intake at a firm very seriously, watch what is going on, participate, get involved, get your feet and your hands dirty, get in there and learn. And that may enlighten you to say, hey, you know what? I never thought that I'd do human rights. I really like that. And that may inspire to go in that kind of direction. The two disciplines I don't see a lot of paralegals in is human rights tribunal. It's a lawyer's game. So the way I look at it is you got to be up on your game and know procedure down, because you don't want to look like you don't know what you're doing in those types of forums. And maybe that's part of it too, that it's a confidence thing of not knowing. And also, I would say another equivalent would be criminal court, not just going up and doing set dates, actually representing the client from start to finish. You've got to know the procedure, or else you're not going to survive. So it takes time. It doesn't happen overnight. And it's a constant learning process. I've been licensed. I'm in my 6th year, and I'm learning every single day. I have a very solid background leading up into paralegal, but there's things I'm learning every single day. Oh boy, I won't be doing that again, right? Those types of things. So follow your passion. Sophia is correct. Follow your passion and be good at whatever you're going to do. That's my advice.
Perfect. So Sophia, Leon, thank you both for joining us. And it's nice this time I have Sophia as well. I think this is the third or fourth time Leon spoken with my students. I wish you all the best if you get to catch the Rib Fest there. I mean, it's nice weather this weekend out here in Durham. So all the best for everyone listening and all the best for the two of you. Take care.
Great, thanks
Thank
so
you
much.
very much. Thank you so much.